of New Jersey versus Victor Montanez under 2023 144 1214. Appearances.
Justin Hamlin, Assistant Prosecutor for the State.
Uriel Carpenter on behalf of Mr. Montanez, who is appearing virtually from the Middlesex County Jail.
And he is participating with the assistance of our court interpreter. We will swear or affirm Ms. Dahlman.
Vamos a juramentarla.
Please state your name for the record.
Tatiana Dahlman, D-A-L-L-M-A-N-N, AOC approved, Spanish interpreter.
Do you solemnly swear or affirm that you will interpret accurately and impartially, follow all guidelines for court interpreting that are binding on you, and discharge all the solemn duties and obligations of an official interpreter?
Yes, I do.
All right. And Ms. Carpenter, you mentioned that you had a conversation with your client potentially about consenting.
Yes, Judge, I did, but he has decided to go forward with the hearing, so he will not be consenting to detention at this time.
All right. So with that, I will hear first from the state regarding probable cause.
Thank you, Your Honor. Mr. Montanez is charged on warrant 144 with 5 charges resulting from the burglary and theft of a motor vehicle that occurred here in New Brunswick on February 11th at around 7:30 p.m. Including in those charges are second-degree eluding charges, which are the most serious counts for today. On that date and at that time, the Brunswick Police Department was notified by one of their own officers that his personal car was stolen from the parking deck underneath 25 Kirkpatrick Street here in New Brunswick. A review of security video showed this defendant walking in the parking area of the basement area, which would have been accessible from either the stairs behind City Hall or the parking ramp at Kirkpatrick Street at around 6 o'clock. At 5:55, and then at 5:59, the victim's car is seen pulling out of, and the defendant driving his car out and out of the parking deck onto Kirkpatrick Street and ultimately onto Livingston Avenue. Police were able to identify this defendant as he had been arrested earlier in the same day wearing the same very distinctive jacket for the burglary and theft of, which is now Promise Gavel File 23677, for which he was placed on summons. That was a motor vehicle burglary that occurred over on Kirkpatrick Street near the Wellness Deck. When the pickup truck is stolen, obviously the New Brunswick Police alert all surrounding jurisdictions, and this defendant was observed driving the vehicle on Livingston Avenue. New Brunswick Police terminated their pursuit when it became dangerous to continue based on the operation of the car by this defendant. And North Brunswick Police also began and then terminated pursuit, notifying New Brunswick Police that this defendant was coming back into town on Livingston Avenue. Observations by officers from New Brunswick, they see the car coming, and in fact, one of the officers describes having to swerve his marked patrol vehicle out of the way to avoid the collision that he would have otherwise had with the vehicle that was being operated directly at him. They follow this defendant on further down Livingston Avenue. It's 7:30 p.m. at this point. There is 7 to 7:30 p.m. at this point. There is
Judge.
Yeah.
Hold on, Judge.
You having trouble here?
Motioning that he couldn't. He was motioning at the phone. I just want to make sure you can hear.
Yeah, where's Tatiana?
Where's Tatiana? I also don't see his uncle anymore.
So I'm busy reading her. I didn't notice.
All right, you may
Yeah, she's not on the Zoom right now.
All right, you may have to back up and repeat while we try to get her back on. Muriel, maybe you could tell us what's going on. We're going to backtrack because we lost the connection.
Sounds good. Señor Montañez, perdimos la intérprete, entonces vamos a reempezar con la intérprete cuando regresa. ¿Ok?
I'll be right back.
Entonces solo espere algunos minutos.
So this is the State of New Jersey versus Victor Montanez under W 2023-144-1214. Appearances of counsel.
Hudson Hamlin, Assistant Prosecutor for the State.
Muriel Carpenter on behalf of Mr. Montañez, who is appearing virtually from the Middlesex County Jail.
And we will swear or affirm our interpreter.
Please state your name for the record.
Miguel Dominguez, Spanish interpreter, approved by the AOC of New Jersey.
Do you solemnly swear or affirm that you will interpret accurately and impartially, follow all guidelines for court interpreting that are binding on you, and discharge all the solemn duties and obligations of an official interpreter?
Yes, I do.
We are here to address the state's motion to detain Mr. Montanez. I will hear again from the state regarding probable cause.
And I'll start from the beginning. Warrant 144, which is before the court today, is the result of this defendant's actions on February 11th of this year. At about 6 p.m., this defendant entered the parking deck of the New Brunswick Police Department, located beneath 25 Kirkpatrick Street, stole the personal vehicle of one of the officers, and fled onto Livingston Avenue. There is video showing this defendant walking in the parking area, wearing a very distinctive jacket, and that area would have been accessible either through stairs behind City Hall or the ramp from 25 Kirkpatrick Street side of the building. He was seen walking around at 5:55. He was recognized because the defendant had been arrested earlier that day for motor vehicle burglary, which occurred at 100 Kirkpatrick Street, which is the wellness deck, or the street behind the wellness deck, and had been released on a summons 142, and was recognized by the officers. He is then seen driving a car out of 25 Kirkpatrick Street behind the wheel of the officers, behind the wheel of the officer's pickup car. The officer had left his keys in the car, which is common practice in the secure deck, so that people can move their cars if need to access other, because the cars are parked 2 or 3 deep sometimes now, so we can crack it. So keys were left in the car and moved the New Brunswick police encountered Mr. Montanez driving his car down Livingston Avenue, and due to the hazardous driving of this defendant, terminated their pursuit. North Brunswick did likewise, also on Livingston Avenue. They started and then terminated pursuit due to this defendant's driving. North Brunswick alerted New Brunswick that the defendant had turned around and was coming back into New Brunswick on Livingston Avenue. They observed the defendant driving at one of the marked units that is involved in this. And that marked unit has to take evasive steps to avoid collision. This defendant then continues to drive towards downtown New Brunswick on Livingston Avenue through what is described as moderate car and foot traffic. This is just after 6 o'clock. This is just after 6 p.m. on Saturday. He is going 60 miles an hour on Livingston Avenue, which is a 25-mile-an-hour zone, and almost hits 2 pedestrians at the corner of Joyce Kilmer and New Street near the Family Court. Again, pursuit is then terminated. Other officers who are working off-duty at the State Theater, which is either letting in or letting out from a performance, see him. They see him also make that turn from Livingston to New, and again, there was pedestrian traffic. Ultimately, he is arrested on Route 18 by East Brunswick Police down by the Chili's a little further down. Based on the operation of the motor vehicle, New Brunswick, North Brunswick, and will striking the others, he is charged with eluding charges. He is charged with theft of the motor vehicle, burglary of the motor vehicle, and arrested, he has in his possession a round of handgun ammunition, and he does not have a permit for an FID card that would permit him to have. Based on that, Judge, I'd ask you on probable cause for these charges that are before the court.
Thank you. Ms. Carpenter, as to probable cause?
Your Honor, I'll stipulate to probable cause for the purposes of this hearing.
Based upon the proffer and stipulation, probable cause is established. I will hear from the state as to why he should be detained.
Judge, we go beyond. Obviously, the state has to provide you with some information beyond the bare facts of this case. And I think here, the defendant's conduct is so egregious, Judge, so dangerous to the community at large, that even beyond the mere facts of burglary, that, Judge, that his conduct and his behavior warrants his pretrial detention. This all started after Mr. Montañez had been charged on a motor vehicle burglary and released and released with a court date of March 2nd for CJ Day. For whatever reason, he made an affirmative step to go back to New Brunswick Police and go back into the sub-basement or basement of the New Brunswick Police Department and went in there and stole a motor vehicle. That is beyond brazen and beyond. And that area, Judge, is also not open to the public, so the mere act of going into the garage, even if he had not gotten into the car, would be criminal trespass in and of itself. And then not only to steal a car, but to lead multiple police departments on chases, to put numerous drivers and numerous pedestrians, even more significantly, in danger as he's driving 2 to 3 times the speed limit on Livingston Avenue, going towards the State Theater, swerving off onto New Street, and again, almost hitting 2 additional pedestrians in front of the family court area, in that area from my office right over there, is terribly concerning. So he did this while having been released on earlier charges. Public safety assessment had been run on those. New Brunswick Police acted absolutely in accord with what the public safety recommendation was in terms of warrant versus summons. And having been given that opportunity to be released and to walk away and to go about his business, he elected to engage in this course of conduct that placed dozens of individuals at serious risk of injury, including, as I said before, driving at a marked police car in this pickup truck. Judge, not only based on the facts of the case, but the fact that this defendant creates a substantial risk to the community going forward, and is likely, and I think, Judge, there is a likelihood that he would reoffend. He reoffended by doing this. He reoffended within hours of committing a burglary, probably within moments of being released. I don't have the booking time at the time he was released on 142, Judge, but it was within hours of his initial contact with law enforcement. It's a mystery to me, Judge, why anyone would want to think this was a good idea, but that's why we do this for a living and not real estate. I think there's a substantial risk to the community. I think it is strong that he's likelihood that he is going to reoffend. Judge, I can't tell you he's got a prior record. I don't know what his ties are to the community. And I know that, but I don't know what his long-term ties are to the community. I can't identify any one way or another. Based on all the facts presented by this case, by this defendant's actions, and the risk of repeat offense and the risk to the community, Judge, I ask for pending resolution of these charges.
Thank you. Ms. Carpenter.
Your Honor, with the amended public safety assessment, the recommendation to the court is that Mr. Montañez be released on his own recognizance.
Oh, I don't have that one. I have one that shows bi-monthly, has a level 2 recommendation.
Yes, so that was since corrected by pretrial services to reflect that the charges on the summons are also considered to be current charges and not pending at the time, just because of the short duration between them.
And Judge, let me break in there. I would agree that the charges from East Brunswick would qualify for that. I would disagree, and that 142 is not a separate charge because it's its own criminal event that was charged, and he was released on that charge. I don't care whether it was 5 minutes or 5 hours or 5 months.
It's a separate incident.
Yes.
Is there any dispute that he had been released on the other charge before this incident is alleged to have happened?
No, Judge. I had conferred with pretrial services, and they had found it appropriate because it was the same day to list them as active charges. That is the new PSA. Regardless, it does recommend release. So the original PSA recommends the twice per month.
Double check.
The twice per month checking in the court. And Mr. Montañez, until this one day, had absolutely no priors, no prior convictions, and no pending charges. So as Mr. Hamlin noted, in order to detain Mr. Montañez, the court would need to find something beyond just the nature of the allegations against him based on mistaking Mercedes. And while Mr. Hamlin has noted that this is egregious conduct, it is risky conduct, that still is related to the allegations and not to any other factor for the court to consider in this case. Mr. Montañez lives with his uncle, who is present on the Zoom, Adriano Ngulamoto. He has his video on. Mr. Montañez has a room in his house, lives with his uncle and his uncle's family. Mr. Montañez also works. He cleans houses Monday through Saturday consistently with his aunt, Mari Carmen Ngulamote, the sibling of the uncle that Mr. Montañez lives with. So he does have strong ties. In terms of the ammunition charge here, Judge, I believe that, and this is based on the police reports, but I believe that the ammunition charged for Mr. Montañez is actually ammunition that was present in the car. So just to clarify that I don't think there's any allegation that Mr. Montañez had a possession of weapons or ammunition prior to this event taking place, prior to these allegations. Mr. Montañez also,
I just looking at the affidavit of probable cause, it does say search incident to arrest. The defendant was found to be in possession of a single .40 caliber ammo. That implies to me that it was found on his person.
It does, Judge. Looking at the police report, it does not say that was from a search incident to arrest. There's a notes of what was in the car, according to, I guess, police records of what was contained in it, and that does list ammunition. So, I'm not entirely certain, but and I'm also not a gun expert by any means, but when I looked up these rounds, it looks like they're used for things like crowd control, which I find to be more likely to have been present in the car than to be a round that someone is just carrying on their person without a gun or any way to use it. So I was somewhat confused, honestly, by the complaints, and it's possible that he had pocketed something from the car, but I wanted to clarify that I don't see any allegation of him having been walking around with weapons or ammunition prior to this.
All right, but it would be extra physical evidence that supports the state's case that he stole his car.
That's true, Judge. And I think, this is a hard charge, or a hard course of conduct to understand, why somebody would do something like this. And I know that Mr. Montañez's uncle has concerns about Mr. Montañez's mental health and told me that he wanted to get Mr. Montañez enrolled in some kind of a mental health program in order to, assess whether he has needs that should be met through some kind of counseling or therapy. And Mr. Ngulamoto's uncle is willing to be the custodian trying to find, any appropriate treatment that that could fit whatever Mr. Montanez's needs are. It was my first thought looking at this complaint because it is hard to understand what the goal would be of someone doing this. And so, with that, I think based on his utter lack of record prior to this, the fact that he does have a job, he does have supportive family, and he does have, family that is supportive enough to try to get him any help that he does need. I will ask the court to release him on level 3 so he is able to continue his work cleaning houses with or without a person attached.
All right, this case comes before the court on the state's motion to detain Mr. Montanez, and probable cause has already been established. The next step is to determine whether the state has demonstrated by clear and convincing evidence that there are no conditions that would assure the safety of the community. And why the brazen nature of this allegation is so important is because it is hard to understand how or why anyone would do something so brazen. And if you would do something so brazen, I find it very difficult to believe that he's going to follow orders. Now, the PSA recommends that he be released on level 2. He's got a 2 out of 6 on the risk of failure to appear, and a 4 out of 6 on the risk of new criminal activity. He's 20 years of age, and he has no adult or juvenile record, but he's now charged with some very serious charges. These second-degree eluding charges could carry 5 to 10 years in state prison if he is convicted. And it does appear that the strength of the state's case is very high based upon the video, based upon the officer's observations, based upon the physical evidence of the ammunition that was discovered. And what is as disturbing as the brazen nature of this allegation is the fact that he had been charged and released shortly before he then goes on to allegedly commit a similar crime, now in the home of the police department. Mercedes tells us not to detain someone just because of the serious nature of a crime. However, here, the state has a very strong case, and when balancing the various factors, I am made aware of the mental health issues that may exist here, that may be part of the reason that this situation arose. But that same mental health issue also makes it very difficult for conditions to assure community safety. So balancing those character impairments with the very serious nature of this crime, beyond just the brazen act of taking this car out of the police deck, the fact that he was going 60 miles an hour in a 25 miles an hour zone, more than 60 miles an hour, pedestrians in a very busy and populated area, means that he is a danger. Although he was not on any type of release, having been charged on a summons and released shortly before this, there was always an obligation to remain offense-free. Based upon the totality of the circumstances and acknowledging his uncle's devotion to him and willingness to help find a program for him, I do believe that there is a danger to the community that no conditions can control at this time. However, if an appropriate program can be found, the court would be willing to reconsider his detention and release him directly to that program. So you are detained, and you do have 7 days to file an appeal of my decision. This hearing is complete.
Judge, can I ask one thing, and this is actually for everyone's benefit? The summons 142 was charged and is now on a scale of 23,677. Rather than have him go through the CJP process for that and then get another court date and have multiple appearances, can we just list 677 for the arraignment date on the detained matter as well?
Muriel, any issues with that?
No issues with that. Judge, I just wanted to clarify one thing about potential programs.
Okay. Staff, do we have any issues with the listing as suggested by Assistant Prosecutor Ham?
No, Judge, I'll let the CJP team know if this is taken care of.
Okay. Muriel, you had a question about programming.
I did, just because there is no inpatient mental health program in our area, would an outpatient intensive program be something that the court would consider as a placement, just because I don't think there is anything?
Potentially, if you can give me some details of a program that you might be able to find for him.
Okay.
And I don't know if Dr. G or the staff at the jail would have any type of records that might give us some idea if there is any type of diagnosis.
Okay.
But basically, we need more information with regard to that and to know whether or not it can be managed safely.
Okay, thank you, Judge.
Thank you. All right, thank you. This hearing is complete.